Okay, we're going to get going on the presentation for today. Thank you for joining me and participating in our next of the health law webinars. Today's presentation is on credentialing, corrective action, and data bank reporting. I'm Kelly McIntosh. I'm an attorney in our healthcare group and based in the Reno office. And just as an overview of what we're going to cover, I'm going to be trying to touch on these topics generally, so obviously depending on your role in the process, whether you're a facility, a participant, even the type of your facility, some of the considerations may be different, but I'm going to try and give a high-level overview and some recent changes and tips that will hopefully be useful no matter where you may find yourself in that process. So after the presentation, we're going to send out a copy of the slides for today. I'm going to send out a sample credentialing checklist and also a copy of the current National Practitioner Data Bank Guidebook, which was actually just reissued, or an updated version was issued earlier this year. So it's got recent guidance and some clarifying issues that I'm also going to touch on later in the presentation. A few preliminaries before we dive into the main presentation. As with all of our webinars, today's presentation will be recorded on our health law blog. If you have questions, there is a chat line that you can use in the WebEx system. Feel free to send me a message there. If we have time in the presentation, I'll get to any questions that are submitted that route, or they're actually tracked and sent over after. So if we don't get to them on the presentation, I can reach out to you after the presentation and touch base that way. Or also feel free to email me at my email address with any questions or if you'd like further information. And if you have any problems during the presentation, you can reach out to Luke Kelly, and his email address is there as well. As with some of the disclaimers and preliminaries we give on all of our presentations, this is going to be a general overview of legal issues and considerations. Always review your applicable law, and as I mentioned, this is specifically one where the law and process that you may be either subject to or find yourself a part of will be dependent on the type of facility involved, the type of practitioner involved, the governing documents of the facility, and or employment contracts or other contracts that may also come into play. And of course, the state you find yourself in may be different than a neighboring state. This program does not establish an attorney-client relationship and does not constitute the giving of legal advice. So with those out of the way, we can jump into our credentialing. So first question is, who is subject to credentialing? All independent practitioners are subject to credentialing, and that usually will just mean those that are licensed to practice independently. So you'll have physicians, dentists, podiatrists, and then the group, which usually is called allied health practitioners, or can be referred to as AHPs, and that'll encompass advanced practice nurses, nurse practitioners, physician assistants, psychologists, and therapists. Credentialing may not directly apply to other practitioners, but facilities still must ensure that those types of practitioners are qualified to provide their services that they're providing at the facility and have, as applicable, licenses, certifications, et cetera. And that would capture groups of practitioners like nurses, technicians, medical assistants, that kind of thing. Next question is, what does credentialing address? And there are two distinct pieces that credentialing addresses: medical staff membership and privileges. Though they typically go together, they are distinct components, and they're often used in conversation, I find, interchangeably. So I just want to touch on the differences of what those mean, though again, a credentialing process will usually go through if a practitioner has extended both medical staff membership and clinical privileges. Medical staff membership is the right and responsibility to participate in medical staff benefits and obligations, and involves initial appointment and reappointment processes. privileges are distinct from that, and they encompass the license to use the facility resources and provide specified clinical services at the facility, dependent on the education, training, experience, and competence of the practitioner, and the facility's capability to support their requested privileges. So the privileges is really the piece that allows the services to be provided at the facility. So the next question is why credentialing, and this is one, a scary story or a cautionary tale, which some of you may have heard of or not. It's the subject of a book and been many on several kind of true crime shows. This is a physician who in 2000 pled guilty to murdering 3 patients by poisoning them while a hospital physician. And it was actually suspected of lethal injections of far more patients. The thing that was very applicable to this topic with this physician was that the history of what happened in leading to some of these patient deaths showed a trail that potentially could have been picked up by proper credentialing along the way. He had things like warning letters at his medical school, numerous deaths occurring on his rounds. He had been convicted and imprisoned for poisoning coworkers, had pled guilty to fraud and applications to government hospitals. His medical license had been revoked in one state, and he actually had been featured on a true crime type TV show already. So his story obviously was an extreme, and at times he had changed his name and gotten kind of all over the country, but to some very well-known facilities at times, government facilities and pretty well-known academic and medical institutions, and yet was able to jump around and really not be on the radar of many of these facilities as they were credentialing him through their processes. So this is definitely not the type of case that I expect or would anticipate will come across the normal credentialing process often, but was a very extreme example of when credentialing does not happen and does not go through all the safeguards and checklists and processes put in place to get to what may be red flags or warning signs, bad results can occur. Credentialing generally is preventative medicine for a facility because it helps promote quality health care. It avoids problem practitioners, whether that may mean incompetent or disruptive practitioners. It facilitates a professional workplace and prevents liability to patients, practitioners, employees, and the government. And it also is part of accreditation standards, including the Joint Commission's requirements. So on the concept of lowering liability and how credentialing can help avoid or lower liability to distinct groups that facilities may encounter liability toward, to practitioners, due process violations, breach of contract, emotional distress, discrimination, and antitrust are all potential liabilities of, or that could actually be associated with credentialing, but credentialing done correctly and following processes established and not done for improper purposes can lower these liabilities because the facility is going to be able to establish that they did not do anything that was, along these types of liability lines. For patients, the potential liabilities that may be able to be aided by establishing and being able to demonstrate that effective credentialing was in process and took place is to help lower malpractice risks, claims of respondent superior, and negligent credentialing. And in regard to the liabilities to the patients, just a couple other things before going to the next slide. Oftentimes, if there's proper credentialing, you can show that, actions were addressed with physicians or with practitioners when needed. That can help prevent claims like negligent credentialing, where a patient may try to argue that there were plenty of warning signs about a specific practitioner and a facility failed to act or failed to engage in the credentialing processes that they should have engaged in to avoid a poor outcome down the line. So again, that side of it I think is fairly straightforward in the thought that you want to be able to establish that you took the correct credentialing steps. To practitioners, as a general premise, courts are unlikely to second-guess a facility's decision, and this would be in regard to claims of discrimination, anti-competitive activities, breach of contract, failure to follow due process, some of those claims that a practitioner may make about credentialing actions. The situation where a court would be less likely to second-guess those decisions would be if the facility, one, followed their own requirements. So that's beginning with the governing documents that are applicable to the facility. So what is actually in the bylaws, in the policies and procedures, in the credentialing manual, if they follow the applicable statutes. And also if then whatever the decision and the outcome was of the credentialing process, if that was based on legitimate documented reasons, so whether that be tied to patient care or hospital operations, but that it was not an arbitrary and capricious decision, there was no improper motive like anti-competition, retaliation, some of those types of concepts. And definitely, which you'll hear me mention a few times in the presentation, is the process in these types of cases, especially when they get to a judicial proceeding where a court's taking a look at the process. The process is often more important than the decision. So the result, whatever that may be, is going to be a part of what is looked at. But really, the whole process in getting to that result is what needs to have had these earlier components of following requirements and being done in a legitimate, documented manner. So some of the governing standards for credentialing include the statutes and regulations that are applicable to the facility, and first is constitutional requirements, and that would be really tied to the due process component. State statutes and regulations that may govern credentialing and review processes. The Medicare Conditions of Participation, and also the Healthcare Quality Improvement Act, sometimes often abbreviated and then sometimes referred to as the HCQA in that abbreviated form. Also, the medical staff bylaws, rules, regulations, and manuals. So what the facility has adopted as its, and its medical staff has adopted as its governing documents, and practitioner contracts. So if they're separately, our contracts with practitioners beyond just the medical staff documents, what's contained in those documents, and accreditation standards. There are also maybe common law, and that would be often how case law has interpreted credentialing standards, and or if there are standards that have been established in the community. So wherever you're based, if there are community standards that are accepted and followed to avoid negligent credentialing, that would be a good something to keep in mind and could be used as evidence to show that there was no negligent credentialing and the acceptable community standards were followed. Some general standards for credentialing. The physician does not have a constitutional right to privileges at a public hospital. So there is not a right to acquire privileges. However, a hospital must provide due process if seeking to take away privileges, limit privileges, condition privileges, take away what has been granted to the physician on that front. A hospital cannot exclude for illegal purposes. So again, as I mentioned, some of those may include anti-competitive, discrimination, retaliation, that kind of purpose. Hospital must establish rules, standards, or qualifications for medical staff membership, and that will typically stem from some of those governing items I mentioned on the previous slide, so state statutes and accreditation standards. And then those tie into then the substantive standards for credentialing. So credentialing decisions can be upheld on, they may be based on things like current licensure, education, experience, competence and judgment, character and professionalism, hospital capacity and capabilities, ability to satisfy medical staff responsibilities, geographic proximity. These are all things that will be looked at and may come into play in reaching a credentialing decision. And those types of items can be considered, and others, so long as they're reasonable and not taken on a discriminatory basis. Credentialing decisions should not be based on licensure or membership alone. It should look further than just is a physician licensed and that box is checked, so that the credentialing process should go beyond just that kind of a cursory review, and also should not be based solely on credentialing done by other entities, though a bit later I will touch on credentialing for telemedicine and how that's a bit of a different process. So typically, so economic or business reasons may also come into play in credentialing, and most courts, though again, good to, if you're looking at any of these types of items as a consideration for credentialing, want to look to make sure that there's not differing case law that's come down applicable to your jurisdiction. But typically courts have upheld, if there's legitimate business reason and they were permitted in the governing documents of the entity, exclusive contracts, closed staff arrangements, and competitors on medical staff as all being considerations or reasons used in the credentialing process. The Office of the Inspector General has expressed some fraud and abuse concerns with economic credentialing or credentialing for utilization reasons. So again, may not always be completely okay or completely not okay, but before, if you're considering any of the economic or business reasons in your credentialing process, just consider what's applicable in your jurisdiction, if there has been case law on point, and make sure that it doesn't bring in any non-permitted reasons along with what may be okay and acceptable economic or business reasons. The credentialing process, now we'll get into actually what that process usually entails. So typically there are hospital or facility bylaws, and often there'll be rules and regulations. Many times you'll find an actual credentialing manual that covers the credentialing process separate and apart from other rules and regulations. That process usually includes the application, where typically the application process is reviewed on the administration or medical staff office type level. And that would be where information is gathered, submitted by the practitioner. That information is verified, and necessary data bank and license and other searches are run and verified. Then you'll go to the active medical staff review process. That's where the medical staff will get more in-depth and review the application file with all of the information that's both been submitted and verified. Interviews with the practitioner may occur, a recommendation will be made to the board, and if necessary, if there was an adverse recommendation and a fair hearing process is required, that process would occur. Then finally, the governing board of the facility will review the decision that came up from the medical staff and decide if the board's going to adopt that recommendation, reject that recommendation, send the recommendation back for further action by the medical staff, but the board's the final level of the review in the credentialing process. Just be aware, and this will likely depend on the facility at which you find yourself and the governing documents of the facility, but the process may be different whether you're talking about a physician or an allied health professional. So also, before you jump to the next step or think that X, Y, or Z is required or may be required, always double check to make sure that you're following the right process for the right type of practitioner. And I would just note that you may consider, even though it's sort of, through my description already, I described it as this way, but consider this as a two-step process where really on that application front and the things that fall under that, there's a screening for basic eligibility, and that's done by the medical staff office. So if a physician is applying and they don't meet a basic qualification, they don't have the right licensure or the right insurance threshold or something that's just a requirement that can be objective, an objective qualification that can be checked to see if it's met or not, then an application could be denied summarily if they fail to meet that objective qualification. The second step then would be to review for competence and capability. That's the piece where you're talking about the active medical staff review. And that would be only go to that second step if the first basic eligibility step has been met. So again, trying to get through that first step before moving to the second should help weed out applicants who would be ineligible because they just don't have some of the qualifications required, and may also prevent peer hearings and data bank reports if an application is denied for not meeting an objective qualification. That will likely or may not trigger any of the due process, is likely not to trigger due process requirements and data bank reports, whereas a denial based on competence or capability is likely to trigger those items. So trying to keep them in order where you may not get mixed into the second piece if the first piece is not going to be met anyway, can just help save some of that administrative steps. And also data bank reports and other things that could have substantial impact on a practitioner, even if they would have not made it through the first part of eligibility because they didn't have one of the objective qualifications. So as I mentioned, one of the materials that we sent around is a credentialing checklist, and it's general, but can give some insight as to maybe some of the items to consider in the process as you're going through the credentialing standards. Definitely make sure that before you just take that and use it as is, make sure it matches up with your governing documents, your state's laws. Likely you're going to need to do things outside of the checklist by far, but it definitely, whether you use this or have a different checklist, because the process is so important, I find that setting out the steps and just making sure that either every step was followed, or if it was not, there was a reason because it wasn't applicable in this circumstance or whatnot, that the process is always laid out, and so you can check through and make sure that every item in that process is followed. And going to that process, so in the governing documents of the facility where credentialing is an issue for you, whether you're the facility or practitioner, be sure to check under the relevant facility documents who has the burden to produce relevant documents related to credentialing. Usually that would be on the applicant to submit that information, and from a facility perspective, really is a good idea to make sure that that clearly is on the applicant, because as a facility, you typically don't want to be chasing down information, and the applicant should be the first step of the burden first to present that information with their application. If there are deficiencies or missing information, check and follow the process as to how how the applicant's given notification, whether that's something that's completely missing or incomplete information. And along with that, if, again, check the governing documents, but their notification may be given that the application can't proceed until the missing information is provided. And also want to check in the governing documents to see if misrepresentations in the application would be a basis for automatic denial of the application. Often that will be the case, but should see if that's specifically called out or how that's addressed in the governing documents. Also in the process, one of the important steps is to query the necessary data banks and lists. So that includes the National Practitioner Data Bank, the list of excluded individuals, and that's because federal health care program participants cannot contract with an excluded provider or bill for services ordered by an excluded provider. So facility wants to make sure that they're not credentialing someone who's excluded. One item that I suggest also be checked, and often here is not maybe necessarily checked throughout the credentialing process, but to make sure that you check the opt-out list as well to see if the provider, the practitioner involved has opted out of participation in Medicare, because if they have opted out, then they cannot be a part of any services that are billed to Medicare. And especially with more the allied health professional level, I've encountered where mid-level providers have been part of a group that actually has opted them out. They weren't really aware of what that meant or that it was ongoing, and so didn't think to notify anyone in the future that they were opted out, but then came to find out that they were still opted out and had a time period where they could not submit any claims to Medicare. So as a facility wants to make sure that it's not going to be running afoul of any requirements on that front either. State professional boards want to check to make sure that the applicant is licensed, see if there's been any actions taken against their license, and especially verify if anything was reported as taken against their license. So in the credentialing process, I would say beware if there are red flags that come up, but also consider appropriately any red flags you see in the context of the application overall, and just definitely if things come up that suggest red flags, consider them, but put them, make sure that they're looked at in the bigger threshold of a reasonable decision based on all the circumstances involved. So some things that may be red flags and may warrant at least further questions, if nothing else, would be if references indicate problems, there's discrepancies in what information is submitted, if there are unexplained gaps in time of professional activities, if there had been either prior disciplinary actions or reported losses or reductions in privileges or licensure, if there seems to be an unusual amount of malpractice claims, especially within a short period of time, and sometimes just unexplained refusals even to disclose information may be a bit of a red flag or prompt further inquiry. So again, keep those in mind and consider them as part of the overall process. So following the review of all the information the applicant submitted, information that may have been supplemented, all of that, then the medical staff takes action, meaning that they can either require more information yet if there are still questions or pieces to be filled in. And then they may also make a recommendation. So the recommendation could be granting membership in specified privileges, or recommend denying, limiting, or conditioning privileges. And the second piece, if the recommendations for denial, limitation, or conditions on privileges, that's likely to trigger due process rights. So again, they'll check the governing documents to see when and how due process rights attach, and then the notification and how that process gets started and triggered. So upon receipt of the medical staff recommendation, the medical staff makes that recommendation, submits it to the governing board of the facility. Then the facility can accept the recommendation, reject the recommendation, send back to the medical staff for more action, or could take separate action. So if it actually thinks a condition is warranted or not warranted, could modify the recommendation to take its own action. And when reviewing what the medical staff has recommended, the board's review should look to see if the appropriate process is followed, if the decision was reasonable, not arbitrary and capricious, if it was based on legitimate considerations, and so not illegal or improper considerations. But the board is not expected or required to be medical experts, so they would not as much be looking at the medical specific pieces necessarily that the medical staff may have considered. As mentioned, and I'm sorry, and one actually before I get to that last one. So the board also is the one that then determines what privileges are granted. So that may be done through all the list, kind of the all list of privileges of what could be available at the hospital. And that often you'll see more in small hospitals that only have limited procedures, and would require regularly updating a physician regarding what procedure or what privileges and what physicians are outstanding. There's also then more core privileging that are certain departments, so identifies privileges associated with a department, allowing for additional privileges, but may be specific to what that physician actually what practice area they'll be in, their specialty, that kind of thing. So depending on the size and type of the facility, you may see that the board identifies privileges differently. As I had touched on earlier, telemedicine privileges are considered a bit differently than other regular credentialing and grant or consideration of privileges. So under the Medicare conditions of participation, hospitals are allowed to rely on credentialing done by remote facilities for telemedicine if there's an agreement in place between the facilities, the remote facility complies with the conditions of participation, the practitioner in question is privileged at that remote facility, the practitioner is licensed in the state where services will be provided, and the hospital reviews, the hospital meaning the hospital that is receiving this practitioner services through telemedicine, reviews their performance and then reports to the remote facility where the practitioner is actually credentialed. But then the big distinction that may be very different based on where your facility is located, confirm what's allowed under your facility bylaws as a main step, and also, very importantly, under your state licensing statutes. State professional boards have approached telemedicine differently, and some are still evolving how they're handling telemedicine licensure. So confirm what it means to be appropriately licensed in the state where a patient will be receiving the services, to ensure that you're not going to, well, you may be okay on the Medicare conditions of participation front, you will also be okay on the state law. And finally, just a note on this, would also suggest that as you're engaging in any telemedicine credentialing or considering telemedicine privileges, also consider how this may open exposure to negligent credentialing claims, or how active this process will continue to be. Again, just thinking that negligent credentialing claims could be maybe made or attempted to be made based on the thought that the facility was not taking appropriate steps to review and provide oversight or pick up on issues when they had the chance to do so, and then that resulted in some harm down the line. Check your bylaws for emergency temporary privileges. When those may come up, they're usually very limited circumstances where there's just not time. There's a need for the practitioner, but there's not time to go through the whole credentialing process. They'll typically expire after a specified period of time, and that actually on the facility side is a good thing to have in place, so that they don't just, temporary privileges don't stand out for a long period of time. And on the facility side, a good idea to use emergency or temporary privileges sparingly, because a practitioner would then be providing services without having gone through the full review and detailed process that should be done for full credentialing. Reappointment is typically going to occur at least every 2 years at a facility, or in most cases will be very similar to initial appointment. And again, that process should be spelled out in the facility's governing documents. So on to then corrective action. So first is a kind of why, or how we get to corrective action. An organization has the right to ensure it has its effective operations. On top of that, an organization has a duty to protect its patients and employees. The medical staff at a facility is responsible for medical care, professional practices, and ethical conduct of its members. So that encompasses clinical, ethical, behavioral concerns, meaning potentially disruptive conduct, compliance meaning governance of laws, bylaws, rules and regulations, program participation, so a lot of different elements. And with corrective action, I would say there's always a bit of a dual considerations, because if a facility fails to act, they can be liable to patients, employees, or regulators because of malpractice, negligent credentialing, a host of issues. But similarly, not similarly, but kind of conversely, if they act, but they act improperly, then they could be liable to practitioners for breach of contract, not providing due process, antitrust, discrimination, interference with business arrangements, emotional distress. So the bottom line is to try and proceed in the correct way as you go through corrective action processes. The good news, though, is that courts usually don't second-guess a facility's action if it's based on appropriate factors with a valid patient care or business reason, not arbitrary and capricious, and the practitioner is given the due process required by the contract, if they have a contract, bylaws, or applicable law. And again, that's a big instance where the process is maybe more important than what the actual decision or result of the corrective action will be. Make sure that the steps taken in the corrective action are consistent with any contract with the practitioner, the governing documents of the facility, applicable law. On corrective action, always check the governing documents when you're looking at an action that may involve termination or suspension. So as automatic action, so automatic termination, automatic suspension, meaning that there's no process involved, there's a triggering event that just takes away or really takes away the privileges. Those could be loss of license if a practitioner does not have their licensure, then often that will be an automatic, the privileges are terminated as well. Loss of malpractice insurance may be the same, exclusion from federal health care programs, sometimes even items like failure to timely complete medical records, and convictions of felonies or healthcare fraud. There may be other reasons listed in the governing documents, but that's it's a good idea to be familiar with what's in your governing documents. If you're on the facility side, make sure that they're encompassing of everything that should be listed there. On the practitioner side, make sure you're aware of what actions could be taken if certain events happen. Also, with automatic actions, check to see the process as to who can actually, what individual or body at the governing body at the hospital has the authority to terminate or suspend for these automatic actions. How does that notice need to be given? What process is involved? Sometimes corrective action may have related informal responses that don't rise to a full process. These informal responses can be very effective in certain circumstances, but they're not always appropriate. So you need to determine what's going to be the appropriate response given the circumstances around the corrective action or the issue that's being addressed in your circumstance. Some informal responses may include physician interviews, oral or written reprimands or warnings, proctoring or chart review, counseling and treatment, education and training, voluntary remediation agreements. I would caution you that keep in mind or remain mindful of what some of these processes may have in terms of impact on later actions or reporting requirements. For instance, if a facility takes a stance that they're going to do informal responses with just oral warnings or oral reprimands, does that on several occasions, never really has a documented record of events that may have occurred and where a practitioner was addressed and had some interaction that said that a certain behavior or activity needed to be addressed or was not acceptable. And then at a certain juncture, the hospital or the facility decides that it wants to take serious action. It can be problematic to jump to a high level of corrective action, which is really accounting for several past events as well, if those events were not documented. So be mindful of, if you're using informal responses, that those either have some way of still making it to some documented level, or if they're not going to be at that level, that they're they're not consistently used that way, if there's a likelihood or a chance that really this is going to turn into something bigger if these events continue. And also be aware that certain, which I'll touch on when we get into the reporting in a few minutes, certain activities, certain types of proctoring can in and of themselves be something that may be reportable. So also making sure that if you're putting some sort of an informal response or requirement in place, if that is going to trigger any reporting requirements. And check your governing documents to see if there are actually progressive discipline requirements contained in the documents. If so, definitely want to make sure you're complying with those requirements, because again, that could really put a problem in the due process provided when looked at as a whole. So one of the first stages of corrective action, and one very important stage of corrective action, is the investigation stage. So the facts involved in the specific circumstance may require a formal investigation. The governing documents facility may, and it is likely more clear for a facility if they do have a definition of what it means to have an investigation. The investigation or engaging in that process may itself have certain reporting effects, not because there is an investigation ongoing, but if a physician, for instance, surrenders their privileges while they're under investigation, that's a reportable event. When an investigation has commenced, then it needs to be determined how and when a physician is notified. The notification does not necessarily include identifying who has made a complaint or who brought an issue to light. But if, in general, and especially if any of those items are included, or if it's likely that the practitioner is going to be able to guess how a complaint came about, then, you know, mentioning that in retaliation or improper contact should not be part of the response would be appropriate. And similarly, everyone involved in the process should be educated and informed that, you know, retaliation for certain activities should not be involved. An investigating body should then be appointed, and usually this process, again, would be included in the governing documents. The investigating body should be educated both as to, and the investigating body typically would be other professionals, peers, if possible. Usually not preferred, if possible, depending on how big the medical staff and availability of people, but to avoid using competitors or people that have some sort of have a conflict with the person under investigation. Avoid using anyone who might need to be on a hearing panel later, because if an individual is involved in the investigation, then they should not later be someone who's tapped to sit on a hearing panel that's reviewing the process and the decision ultimately reached because of that investigation. And sometimes it may be appropriate to use outside reviewers, a peer review network, that type of thing. When educating this investigating body, good to give the scope of the investigation, educate them on the substantive standards that apply to the investigation, the alleged misconduct or action involved, go over what is in the governing documents about the investigation process, how this process would proceed, both during the investigation and as then that whatever comes out of the investigation, how that moves through the medical staff, board, you know, how it moves through the corrective action process, educate them about statutory immunity found under the Healthcare Quality Improvement Act, also certain peer review protections that may be included under the state law, and why it's, you know, how those protections both are, how those privileges may come to be, and also how they can be broken. And to that end, the importance of maintaining confidentiality of the process. And even at the investigation stage, consider involving counsel, especially if this is a serious allegation or if it's a difficult practitioner or physician involved. So to conduct, then the investigation should be conducted fairly. The HCQA provides that an entity must make a reasonable effort to obtain the facts of the matter. So reviewing documents, interviewing witnesses, consulting experts. The scope of the investigation depends on what's being investigated, so what brought this about and how the investigation proceeds. However, the investigating body should not necessarily just expand the scope of the investigation by itself. If new things are uncovered during the investigation, then they should be in contact, the investigating body should be in contact with the level or whoever at the facility level referred that investigation or triggered or prompted that investigation, and then appointed the committee, should be in touch with them as to, well, we uncovered X, Y, or Z, so maybe we need to also investigate the separate action that wasn't part of what we initially had commenced the investigation with. But again, should not turn a blind eye if they uncover something different, but just be thoughtful and involved with others at the facility to determine how the investigation should change in scope if necessary. And throughout the investigation process, you know, document legitimate actions, what considerations were made, and then the conclusions of the investigation in a written report to the MEC. The written report will help ensure that this was well-reasoned. If it needs to be defended later, it'll help support HCWA immunity. It would help support the decision if it was taken to judicial review. But be aware the investigation report may be, and probably should just assume that it will be discoverable. So keep that in mind. It likely will be discoverable to the physician, maybe to the licensing boards if they look at action based on something taken by a facility. In a trial setting, if it goes to judicial review or is challenged in court. So the recommendation that the medical staff, MEC, once it receives the report of the investigating committee, then it determines what it's going to recommend. So if it's a favorable recommendation, it makes that recommendation to the board. If it's going to make an adverse recommendation, and that would trigger hearing rights, then notify the practitioner of the decision and their right to request a hearing, alert the board, but don't yet make the recommendation to the board until the hearing process is completed, and then implement the fair hearing process. The board decision, similar to the credentialing, could follow the recommendation, reject the recommendation, or remand for further action. Once the board has made a decision, the physician would be notified and any appeals processes would be followed. Summary suspension will come about, or could be appropriate, or may be appropriate when there's imminent danger to the health or to the health of any individual. And because of that, the need to immediately remove a practitioner. In this setting, the summary suspension setting, it's subject to subsequent notice and hearing, so not before the privileges are removed. Definitely need to make sure that in a summary suspension context, you're still following all the governing documents in regard to summary suspension, and summary suspensions are reportable to the data bank if last longer than 30 days. A fair hearing process, so if there is an adverse recommendation or an adverse action and the hearing rights are triggered, then due process must be given, and if that's based generally, if it's based on professional conduct that may adversely affect patient care. Look to state law, the governing documents, and the accreditation standards as to when fair hearing rights occur and attach. And what is due is based on the circumstances. So that, again, we'll look at the governing documents, the type of practitioner involved, the severity of the action, and any contract actions that may come into play. The Healthcare Quality and Improvement Act, the HCWA that I've referenced on a few occasions, it provides immunity for facilities for most claims arising from credentialing actions if those actions are taken in reasonable belief that the action furthered quality care, and this is talking about either credentialing for appointment or corrective action while a physician or a practitioner is on staff, that the action furthered quality care after reasonable efforts to obtain the facts, after adequate notice and hearing procedures, and in reasonable belief that the action was warranted by the facts. The presumption is that a hospital has complied, and a facility must, a physician must rebut that presumption. A hospital process is deemed to be fair under the HCWA if proper notice is given, the hearing proceeds before a fair-minded officer or panel, the physician has the right to present evidence, and the physician receives a written recommendation. And the last thing I'm going to touch on is reporting adverse actions. So the mandatory reporting that likely or a facility may need to undertake is to the National Practitioner Data Bank and to licensing boards. And the licensing board piece especially will be state-specific based on what requirements are on a facility under the facility's licensing statutes, and also what requirements may be found under a provider's licensing statute. data bank reporting, I'm going to touch on for the last few minutes, and also the new guidebook. So this is the National Practitioner Data Bank, and found in it has its own statutory provisions on the federal front. So action against physician must be reported if it adversely affects the physician's privileges for more than 30 days and is based on competence or conduct adversely affecting patient care. Similarly, if you don't get to that point because a physician voluntarily surrenders or restricts their privileges while under investigation for incompetence or professional conduct, or in return for not conducting an investigation, then that is also going to be a reportable action. A suspension in effect for more than 30 days is reportable, and then any revision or modification to any previously reportable action is also reportable. The revision or modification is separately reported. And those are the musts. There are also actions which may be reported. Actions against other licensed healthcare practitioners may be reported to the National Practitioner Data Bank. So the penalty for not reporting is that failure to report could result in losing HCQA immunity for 3 years for peer review actions or credentialing actions taken by the hospital. However, before imposing such a sanction, the Department of Health and Human Services must give notice of the violation, a chance to cure the violation, and an opportunity for a hearing. So it's not a quick or a commonplace result to lose HCQA immunity, but be mindful that that is a potential consequence for not reporting. And the other piece that's out there is that then in making a report, there's immunity for making a report, so no liability for making reports as long as they're made without knowledge of the falsity of the information contained in the report. Data bank reports must be kept confidential. They can be disclosed as part of a peer review process, but not outside that without the physician's consent. And I would suggest or note that there's an option when you're making a report to check there's several categories of actions and items. If whatever your circumstances does not squarely fit within one of the identified categories, to describe that in the other section is a way to give effective information, especially since that may be disclosed in further peer review processes, but also be accurate in what you're reporting. And improper disclosure could result in an $11,000 fine. Oops. So the new guidebook that I mentioned just came out this year. It provides some new additional information that's helpful for facilities and practitioners in determining when something's reportable and making sure that reporting is done correctly. It reiterates that investigations alone are not reportable. It also reiterates that surrender under investigation or to avoid investigation is reportable. The guidebook goes into that investigation is going to be expansively looked at and would include formal targeted processes used when issues relate to a specific practitioner's professional competence or conduct. So even outside of what may be defined in the governing documents, that's the scope or the expansive nature at which the NPDB is going to be looking at when an investigation is commenced. They did clarify that if a summary suspension is expected to last more than 30 days, the facility does not need to wait until 30 days have passed to make the report. However, if the suspension ends up being lifted in under 30 days, then the report must be voided. And a resignation, they clarified that a resignation while under summary suspension would be reportable. In regard to proctors and the implementation of a proctoring requirement on a practitioner, the role of the proctor is important. They give some examples, but if the proctor is required to proceed with care, that may be different than a retroactive, or that is different than a retroactive proctoring, or something where a practitioner can still, a physician can exercise their privileges without any limitation, but has someone reviewing things after the fact. They go into the employment actions which may affect a physician's employment with a facility are different than professional review actions. They may overlap, and something that has a result on the employment front may also result in something that's reportable because it's a professional review action, but they are different processes, and so why and how an action is being taken is important in determining if it's reportable. And then there are a lot of new, or many new helpful examples. Again, that'll be in the written material, so I would encourage you to utilize that guidebook as you're determining if reporting is required. And then finally, just a few summary and tips on this process generally. So make sure the appropriate process is in your governing documents, especially if you're on the facility side where you have the authority to, or the ability to go through the necessary process to make sure that your documents contain how credentialing and corrective action should occur. Spell out that process. Make sure that it's identified for different types of practitioners, if they're going to be handled differently, that it covers who can take actions, how notifications are given, really, walks through how a process would be implemented. When reviewing a credentialing recommendation, make sure that the process that then is in your governing documents is followed, and that process should also be compliant with all laws and everything. That should be part of the review of your process as well. Ensure that the decision is reasonable and supported by the facts. So once again, not arbitrary, capricious, discriminatory, for improper purpose, that kind of thing. If there are concerns when a recommendation is being reviewed, then the recommendation should be sent back to the medical staff for further review or response before a final decision is rendered. And then finally, if the privileges are denied or condition limited, provide the fair hearing process required by the HCWA and your governing documents. And once again, just follow the process consistently. Utilize checklists or other actions when you can that are going to be helpful, but remember that the process is going to be very important, as much or potentially more than what the result. So that concludes the bulk of the presentation. Just a few additional resources that we at Holland and Hart offer. We have publications on our health law blog and prior webinar recordings. We also have recent client alerts and updates on changing and developing healthcare topics. Our future webinars coming up are interpreters and translators, gifts to or from referral sources and patients, and collection issues for healthcare providers. So hope you can join us for our remaining webinars throughout the year. And once again, if you have any questions, feel free to reach out to me, and look forward to talking with you then or being a part of our next webinar. Thanks very much, and have a nice afternoon.